I'm
Yeah.
Amy Traiter, so I'm a solicitor here at Leigh, and I am a partner and head up our court of protection finance team. So I largely look after clients who lack mental capacity to manage their own finances. So a lot of my clients have had brain injuries from like road traffic accidents or maybe a negligent birth and they need some assistance. I'll also act as professional trustee if they have personal injury trusts, and also as professional attorney if people have a power of attorney, which is something that we'll probably be talking about today. And I've got Anna here with me as well.
Hi everyone. My name's Anna Moore. I'm a partner at Leigh and I work alongside Amy and I head up our court of protection health and welfare team. So the work that I do really focuses on representing family members and individuals who lack capacity in proceedings in front of the Court of Protection. And so that usually arises when there's a disagreement or difference of opinion about what is in someone's best interests relating to issues such as their medical treatment or their care or where they should live. And so I act for the individual who lacks capacity and also their family members in different cases.
Fantastic. So before we get going, because I think you're going to give us first of all an overview of, I think before we managed to get you on I mentioned that you're going to give an overview of next of kin, nearest relative, power of attorney, deputyship and detention. So before we do that though, I'm just going to make it clear that actually as practicing solicitors, you are unable to give personal advice on this webinar today. So your advice will be very generalized. But for the callers on there who have specific issues, they can of course then contact our helpline afterwards to get into the detail. But I hope that the more general advice will allow them to understand what next might be, what it might be next for them. So I'm going to hand it over to you for you to start explaining the different types of the different types of support.
Sure. Shall I start? I was just going to give a brief introduction. This webinar is about next of kin, but I'm actually going to give a disclaimer right at the start. We're probably not going to talk about the term next of kin that much. And the reason for that is because actually the term next of kin, whilst it's really widely used by medical professionals and patients and their families, it actually doesn't have any definition in law. And so people are often quite surprised to hear that even if you consider yourself or someone names you as their next of kin, actually that doesn't really give you any rights to receive information or input on making decisions about the person. And really that's because it's not defined in the law anywhere. What we will go on to talk about is things that you can look at putting in place for you to be able to have input and make decisions for someone. And so there are ways of getting certain rights, but being named as next of kin is a bit of a misnomer. That's not the way to do it. So some of the terms that we'll be talking about today and that will come up, I'm sure, in the questions are things like lasting power of attorney, deputyships, being someone's nearest relative, and also making advanced decisions. These are all ways of giving some legal status and ability to input and be able to assist in receiving information and making decisions about a patient's care. I don't know if it would help to talk about what happens when there aren't any of these structures in place, so there aren't any powers of attorney or deputyships in place, because I know that that can also be a worry for people if they feel that they're not being named as next of kin or any other status, and the person or someone can't be identified. What happens? And that's really when the principles of the Mental Capacity Act come into place, and decisions have to be made in a person's best interests. So if there isn't a close relative that can be identified, I know that people can worry that it means that decisions can't be made for that person, but actually that isn't the case either. And if there isn't a person who can be identified, the people looking after the patient have to invoke the Mental Capacity Act and make decisions in a person's best interests if they can't make decisions for themselves. Clearly the starting point is if a person can make decisions for themselves, if the patient can still make decisions, they do that themselves, so they can name who gets information about what's happening or helps them make decisions. But if they can't do that, if they're unconscious or have any other issues that mean that they lack capacity to do that, decisions have to be made in a person's best interests. And that can be done in a really large number of ways. What it means is that anyone involved in the person's care or their life can sit down and talk about what would be best to try to get to the right decision for that person. So that's really what happens if these structures aren't in place.
So before we go into the structures, Amy and Anna, the different structures that are in place, that loved ones or friends of patients, whoever that is, that closest person to the patient, the next of kin term is used, like you said, and the calls that come through to us are, you know, I'm my sister. You know, one of the quotes from a family is, "I'm a sister, but my relative's wife has told the hospital not to give me next information because I am next of kin, because they are next of kin." And so, you know, what is a loved one's solution in that situation?
I'll start by talking about what the solution might be if there isn't anything else in place. So if a person, if someone is in hospital and they can't make decisions for themselves, so if they're unconscious and one family member has been named as next of kin on the file, but someone else wants to find out information, the starting point really is, what the doctors would have to be satisfied that they are communicating with the appropriate person. And so there has to be a bit of investigation there, because it's very difficult to give a specific example, because everyone's family structures are different, everyone's lives are different. And so I think what the medical professionals would have to be making themselves comfortable with is that they're communicating with the appropriate person. And that could be someone's wife, it could be their husband, it could be their daughter, it could be their parents. But equally, there could be complex family situations, which means it wouldn't be appropriate to communicate with someone's wife, you know, if they've been estranged for many years and they actually have no input into their lives. And so if there is a dispute about who should be communicated with, it's really for the medical professionals to make sure they're working out who is the most appropriate person. And if that cannot be easily resolved, asking for best interest decisions to be made. So asking for a meeting about what is in this person's best interests in relation to communicating with them. And so that would be trying to work out what the situation is, considering all the relevant circumstances, and trying to work out what the person themselves would want. Who would they want you to be communicating with? And so that comes down to, you know, the family structure, their beliefs and values, and trying to ascertain as much information about their family life as possible to enable them to make that decision. So the suggestions that I'd make to someone who's being prevented from getting information is to ask the medical professionals really to work out that they are communicating appropriately with the appropriate person, and if not, ask for a best interest decision to be made around that.
Brilliant, that's really helpful. Tell me, can you explain better interest decision? Like how would that happen?
Sure. In a number of ways. I'm going to keep saying this because the overarching structure on this is the Mental Capacity Act. And again, I need to make it really clear, we're only talking about decisions for people who can't make decisions for themselves. The starting point is, and it's a really important starting point in the Mental Capacity Act, that if a person can make decisions, they should be able to do that themselves. You know, no one else can then get involved. So if a person, even if they're unwell, says, I don't want you communicating with my husband about this, if they have the ability and the capacity to make that decision, that wish must be respected. And so what we're talking about here is best interest decisions for a person who can't make that decision. And so that, again, that best interests is referred to in the Mental Capacity Act, but it's not defined. And the reason it's not defined is quite clear, is because what is best for me might not be best for Amy. People live lives in very different ways. And so a best interest decision is a mechanism where the decision maker, so in this context, it'd be the doctors who who need to share the information, need to make a decision in the person's best interests. And we get some guidance about how to do that in the Code of Practice to the Mental Capacity Act. And that sets out things like making sure you're consulting with others. And that can be quite wide. So who should you consult with? Again, it depends on the person. Who do they live with? Who do they spend their time with? Do they have carers that know them very well? Do they have close family and friends? What do you know about their previous wishes? If they could tell you what they would want to happen, what would it be, and where can you find that? And so that's looking at maybe previous medical records or things that the person has said in the past. And it's investigating the person's views, beliefs, values, and having a process that you can consult with all the relevant people to get to a decision in the person's best interests. And like I say, there is guidance about how that's done in the Code of Practice, but it's not prescriptive because every situation is different. And so it's really just a mechanism of gathering as much information as possible to make the right decision for that person.
Just to add as well, actually, if there are family members or friends, worried that their voice isn't being heard, as part of the best interest decision, if they have an interest in the person in hospital, the doctors should be, they should be able to put forward their view as much as anybody can. Whether they're then given the information back is another story, but they should, if they have an interest in someone's welfare, they should absolutely have their chance to put that forward as part of the best interest decision.
Okay, so in terms of best interests and next of kin, and I think a lot of the calls over the last few years as well is because you've got visiting guidelines, so not as many people were able to visit. So if there was 4 or 5, so say it's a dad and there's 4 or 5 children, one person gets listed as that next of kin despite the no legal standing of that term. And then the other family members aren't getting information because there might be, there could be something between the siblings. Could those those siblings then write in and request that best interests decision meeting to happen?
Absolutely. And it doesn't have to be in writing. You can write in or you can call and ask for this and say, I think there is a disagreement about what is best for this person. It appears there is a disagreement about who you are communicating with. We want to get to the bottom of this and make a decision in this person's best interest. So if a person is feeling that they should be communicated with and they're not, it's making that view known, because sometimes there would be sensible structures in place that the doctors communicate with one person who then shares information, to the rest of the family. But that doesn't always happen. There are various things that might get in the way of that. It could be difficult relationships. It could be the fact that other people think their voices aren't being heard enough. And so, yes, absolutely. If you think you are not being listened to, or that you disagree with what a decision that is being made, the first stage, I think, is to make that known and ask for a best interest decision.
That's extremely helpful. So then there's another term that gets bandied about in line with kind of next of kin, and that's the nearest relative. And again, I think that causes a lot of confusion, especially if we use that scenario of a number of siblings and one parent.
Absolutely.
Can you tell us more about the nearest relative and how that fits with next of kin?
Yeah, so unlike next of kin, nearest relative is a legal status. So it's a position that's defined in law in the Mental Health Act. And so it's got quite a specific meaning because it only applies to people who are detained under the Mental Health Act. So that's if someone is detained usually under sections 2 or 3, which means someone needs ongoing investigation or treatment for their mental health, they will have a nearest relative. And the structure of who your nearest relative is set out in law. So, you know, if you're married, it's your husband or wife. If you have adult siblings, it's then there's a list of priorities. It's quite, you can work out who it is if you look at the law. And that does give you specific rights and powers, unlike next of kin, which is a term that doesn't give you any of that. So as someone's nearest relative, you can ask for information about their treatment. You can apply for them to be discharged from hospital. If someone's detained under the Mental Health Act, there are specific processes that have to happen there, but you can apply and say, I actually think this person should be discharged. Equally, you can apply for them to have slightly different treatment. And so it gives you the right to receive information about the treatment, but also to advocate formally on the person's behalf who is receiving treatment. And again, because it's it's very prescribed in law about who the nearest relative is, sometimes that might not be the most appropriate person. So if it's someone's husband, like the example I gave earlier, what if they've been estranged for 20 years? And so there is also a process about applying to change who the nearest relative is. And that has to be done by going to the county court. So making an application to court saying, this person is not the appropriate nearest relative. You either put yourself forward or put someone else forward. And quite often, the trusts or the local authorities can make that application if they're worried it's not the appropriate person. But there's nothing stopping, if it's your mum or your dad or your brother or your sister and you think you are the appropriate nearest relative, for you making that application as well.
I think that's really helpful. So then going back to next of kin, because I think some of the calls that we often get as well, before we move on to the other issues, some of the calls we often get is friends contacting. And so here's kind of a quote from one of them, which is, my friend is in hospital, their condition is worsening. The hospital cannot find the registered next of kin. What can I do?
I think, and again, it's quite a common example, especially because not everyone has family around. And so, again, the term next of kin is a bit misleading because it doesn't really have any legal definition. So there's no reason that it couldn't be a friend who is appointed as next of kin if there isn't anyone else. Yeah. Equally, some people might not even have a friend to advocate for them as next of kin, but that doesn't mean that decisions shouldn't be made in that person's best interests. And it comes back to what I was saying about best interest decisions being made. So if that friend is worried about what's happening or has specific information, that would be really important information, and that person should be consulted with when decisions are being made. So if it's a long-standing friend who knows this person well and knows what kind of views the patient would have about the treatment they want or don't want, that's really essential information that should be part of this best interest decision-making process. And so it's part of the wider consultation which the Code of Practice says should take place.
So the best friend could contact and ask for a best interest decision as well, and
Absolutely.
be able to prove that, through. Yeah, it's very hard though, as a best friend or somebody that's not a family member, to prove that you are the closest.
I was just to say, they don't necessarily have to prove that they're the closest. They just have to, be able to voice on behalf of the patient, really, and put whatever information they have forward. And if it is, they haven't got any family that I'm aware of, and this is what they normally do, and I know they've got these wishes and feelings, and they can absolutely put them forward even though they're not family. It's not necessary to be close. It's just the best interest test is consulting with everybody who has an interest. It could even be a next door neighbour. Some people have lived next to their next door neighbours for 30 or 40 years, they're and they can even be involved. Absolutely anyone who has a view in someone's welfare can be involved.
Brilliant, that's really helpful.
So it's probably important to note, sorry to interrupt, it's that just the status of the person as well. You don't, as Amy said, you don't have to prove that you're the closest, because it's not giving you a kind of legal status over anyone, but it's meaning that you're part of this process that is meant to be multidisciplinary and cooperative and getting everyone's views. So it's not necessarily that you would then be the person making all the decisions for the patient. It's just that you would have very important knowledge and information that should be shared as part of the process.
No, and I think that's hugely important, because you know, we talk a lot about communication and listening to patients, and I think our Accessing Your GP leaflet talks about sometimes you might want somebody with you to have that conversation, and that, you know, best interest decision, and making sure that who you want there is around the table to support you, which is excellent. So you talked about the legal rights. So I think that brings us on to power of attorney. Would it? Could you explain a bit more about power of attorney?
Yeah, so in essence, if you, a starting point really, it's if you have capacity to, and you want to name someone on your GP files, you know, someone to be consulted with as your next of kin, you know, that's the best way to have somebody on there. Another way, if you have mental capacity, is to get yourself a lasting power of attorney. So this, you can have a document for your finances and a document for your health. And the idea is you, whilst you have capacity to do so, are signing up to this legal document that formally appoints one or two or more attorneys to act on your behalf, either for your finances or to make health and welfare decisions in the event that you're unable to. So it's a really useful document to sort of have sitting in the background for scenarios like this, where there might be a bit of confusion as to who has any rights and responsibilities over decision making if, as Anna said, the patient can't do it themselves. So it's quite a straightforward document. It needs to be registered with the Office of the Public Guardian. As I say, it's really naming your trusted attorneys. They don't have to be family. They don't have to be, you know, your husband, wife, children. It can be a next door neighbour. It can be whoever you trust to make those decisions for you. So often if the patient is in hospital, one of the first questions, you know, if they don't have capacity, the doctors will be interested in whether they have a health and welfare power of attorney, because that will automatically give that person, the attorney, the power, if you like, to make health decisions on behalf of the patient if they aren't able to. So it's a really, really useful document.
So Amy, you said that that's quite an easy document to apply for. Can you give us a little bit more information on that?
Yeah, so it's all online. I mean, most solicitors will prepare them for you as well, but you can do them yourself online. And then there's a registration fee. It does have to be registered to be able to use it. And I believe there's probably about 6 months at the moment. So it's not a quick fix to get it registered. But you absolutely don't need a solicitor to do it. It's always recommended to, so that you can make sure you've got all of the right points in the documents, because especially the health and welfare power of attorney, there is specific questions about life-sustaining treatment, and you can also put in particular preferences and instructions. So, if you have a particular wish to only adhere to a certain diet or always go to church on a Sunday or something, the sort of mechanisms within this document to really put forward your wishes. So it is worth seeking legal advice if you are doing one, but it's all on the Office of the Public Guardian's website to make a power of attorney. Also, just to add as well, actually, if it does apply, that there was, previous to the lasting power of attorney, something called the enduring power of attorney. So if people have, if there are older patients, this might apply to. Quite often back in the day when they did their wills, they also did an enduring power of attorney, which is only for finances rather than health. And they were replaced in 2007 by the lasting power. But it's also worth checking for anybody who thinks their parent or an older person might have one, because then they can get that registered if they've lost capacity. So it's worth just checking in their office.
And I think one of my team has just put the website link from gov.uk on lasting power of attorney. So in terms of power of attorney, so say I decided to give my sister power of attorney, and I still have mental capacity. And at what stage do healthcare professionals realise, you know, that so up till I don't have capacity, that person can't make decisions. My sister couldn't make decisions.
Exactly. Yeah. For your health power of attorney, it's absolutely always your decision, and it's issue specific as well to whatever the decision is. You know, they will always come to you first, and it's only if in that moment of time you are unable to make that decision yourself, they would then look to your attorney to do that for you.
Really
So I think sometimes people are a bit nervous that they're kind of handing over all of this control to an attorney, but it's absolutely not. You know, they can't just, you know, barge in and take over. It's always the person's decision first while they can make it themselves.
Really helpful, thank you. And then can we talk about children as well? I'm going to come on to deputyship, and then we'll talk a little bit about detention under the Mental Health Act. But in terms of children or young people with learning disabilities, or just you know, not having capacity, how to say somebody is, you know, in their 20s, how does which kind of next of kin, nearest relative, power of attorney, where does that kind of sit?
This is a really common issue that comes up, I find, in the inquiries that I get, because quite often parents will have been making a lot of complex decisions for their children if they have a diagnosis of learning disability or, you know, any other disability. And then by the time they reach 18, they're often told by medical professionals otherwise, it's not you anymore. You know, they feel a bit taken out of the picture. And that can be a really difficult and also unhelpful way of dealing with it if you've been the person making decisions and know your child as you do. Even though they're an adult, there are some people who will continue to lack capacity when they turn 18 to make these decisions themselves, and this is what I will be talking about now. It's people that even though they're 18 will still lack capacity and need some assistance to make decisions about medical treatment or otherwise. And one thing you could look at doing if you are the parent or other relative of a person who is going to turn 18 and will still lack capacity is apply for something called deputyship. And so unlike power of attorney, to give someone power of attorney, you need to have the capacity at that time to do that. But there will be some people who never will have that, and so it's similar to power of attorney in that it's an application that you make. There's forms that you fill in, and you have to apply to the Court of Protection to say, I would like to be deputy for this person. And what that does is it gives you the ability to make decisions about issues that are set out in the deputyship order. So it doesn't give you authority to make every single decision about this person. What has to be done is that the deputyship has to be drafted quite carefully, has to be prepared quite carefully, saying that you will have authority to make certain decisions about a person's health and welfare. You can also get financial deputyships, but the ones that I'm talking about really are called health and welfare deputyships. It used to be, and I think things are changing a bit, that the Court of Protection was quite reluctant to grant health and welfare deputyships. And I think things are changing, but what the court will ask is why do you need it? Why can't decisions for this person be made in the usual best interest way, which is what I spoke to you a bit before. Why can't everyone sit down and talk about what is in this person's best interest? Why do you specifically need to have the authority to make these decisions? And some reasons for that could be that this person might need a lot of decisions in quite close succession, and so it just helps to have one person having the deputyship. And so I think you have to make it clear that there is a reason that you need this deputyship, and then the court will look at all the factors and decide whether it's appropriate in this case. The other thing to mention is that if you don't have deputyship, you can still apply to the Court of Protection if there is a disagreement about what is best for the person. We might come on to talk about that, but it's a lot of people get asked, I know, by doctors, do you have deputyship or do you have power of attorney? And if you don't, that doesn't mean there isn't a way of you applying to the Court of Protection to get their guidance on making decisions.
Really interesting. So in that example of a young person who doesn't have capacity to make decisions, or in a person who loses capacity, have I picked this right, that you would start with the best interest decision, and if that didn't work, then deputyship could be the next option for somebody?
Yeah, it could be that you start with the best interest, but it could be that actually you think, my son or daughter, my sister or brother is turning 18 and is actually going to need someone making quite a few decisions about their health and welfare. So actually it might be helpful for us to apply, you know, as an individual or a few of you to be deputy. So yes, you might start with the best interest process, and you'd obviously have to consider before you make the deputyship application whether you think it's in their best interest for you to be their deputy, but it doesn't always follow that there would be a formal best interest decision before making the application for deputyship.
Okay, that's really helpful. And all of these, so from your power of attorney, your deputyship, you said the power of attorney, the costs for applying to power of attorney aren't high, and you don't need legal representation, but it might be helpful to get some legal advice. Do you need legal representation in terms of deputyship?
I mean, again, all the forms are online, you know, should you want to do it. I think you get a better chance if you have a solicitor helping you draft the paperwork, particularly with these health and welfare applications, because as Anna said, they aren't that straightforward. And actually, historically, the court's always been reluctant to grant health and welfare deputyships for the reasons she said. So I think definitely if that's something that someone is looking at doing, I would absolutely recommend they get a solicitor to help prepare, to get all of the evidence together to show the court exactly why they need it. Otherwise, you can be waiting a long time, paying your application fee, and then have to, you know, perhaps not be successful and have to do it again.
So you'd have to keep applying. I see that Maya's put the feeds in for the different applying for the for deputyship into the chat, and I suppose, you know, we've got people might be quite feared about how much kind of legal legal charges they may have to do that. Is there somewhere they could go to get some more advice on that?
I mean, the Citizens Advice Bureau always give free advice, don't they? We quite often, you know, depending on what the queries are, I quite often have a quick chat with people to give, they just need a little steer. We also have, do we have legal aid contract?
There isn't legal aid, unfortunately, available for applying for deputyship. And so legal aid is available for some applications to the Court of Protection, but unfortunately not for deputyship or power of attorney.
But the first place, it could be citizen advice, and then thinking about which legal firms in their area. Okay, then I think the next thing that we should discuss is detention under the Mental Health Act, and how that I know I'm using next of kin, but it's a common language used by all patients. Tell us more about detention under the Mental Health Act and next of kin or nearest relative.
Yeah, this is when really nearest relative is the most relevant term to use, because as I said at the start, next of kin, if you're put down as someone's next of kin on medical records, which does often happen, it doesn't actually give you any authority to receive information about someone's treatment. And so someone being detained under the Mental Health Act, it's a very worrying time for them and their families. And so it can often be hard to get that information. But as I said before, there will be someone who is the person's nearest relative, and that person is entitled to receive information about the treatment that person is receiving. The nearest relative can also apply to the mental health tribunal if they think the person should be discharged from hospital, and they can object to you being detained. you know, if you think actually my family member shouldn't be detained under the Mental Health Act, you can raise formal objections to that. The nearest relative can also ask for the person receiving treatment to have an advocate appointed. So the powers given to the nearest relative are quite wide-ranging, especially thinking about the term next of kin, which doesn't really give you any authority at all. Being someone's nearest relative does. And as I said before, the law sets out who is your nearest relative, and that doesn't take into account the nuances of someone's life. So if you think the wrong person is acting as nearest relative, you can apply to court to have, it's called displacement of nearest relative, but to have that person changed.
And you're reading my mind, because that was going to be my next question. In all of these, nearest relative, power of attorney, deputyship, what have you got deep concerns that that person hasn't got the best interests of the patient at heart?
Yeah, and that can happen, because there can be, unfortunately, you know, some people that wouldn't be acting in the person's best interests. I'll quickly deal with nearest relative, because it's a slightly different framework to the rest of it, is because the nearest relative is appointed under the Mental Health Act, and so to object to a person's nearest relative, or to put yourself forward instead, you can make an application, and that's an application to the county court, and you will be asking the court to displace the person that you're worried about and put in someone else as their nearest relative, so to substitute them with someone who would be acting in their best interests. And so that's an application to court, and that application can be made by a concerned family member or friend. They are often also made by social services or the medical trust, if they are concerned that the nearest relative isn't acting in the person's best interests.
I think just to add as well, if it's an attorney or a deputy that you're concerned about, you can also flag it up to the Office of the Public Guardian, which is the department which oversees attorneys and deputies. So if there are ever concerns about wrongdoing, wrong decision making, it can always be flagged up to them. The safeguarding numbers in particular, you know, as well as the hospital's trust, you know, to notify them.
So I'm looking back at one of the queries that came into our helpline. So say you're both parents or carers, two carers or two parents, and one is named either as next to kin or nearest power of attorney, and the other parent isn't, or the other carer isn't, and there's a family dispute. What can the other person do?
In this situation, again, I'm saying this all the time, but this applies to a person who doesn't have capacity to make their own decisions. Starting point, you can ask the Court of Protection to become involved, which can seem quite, a lot of people call me and it sounds quite worrying or quite serious, to ask the court to get involved. But actually the Court of Protection is there to make decisions in a person's best interests when there is a disagreement. And so quite often there can be a disagreement, and it's not that anyone is acting you know, in a way that's concerning. It's just that there are legitimate disagreements about what is best for a person that can arise quite commonly. And so in that circumstance, you would have hopefully tried to resolve it by way of a best interest meeting. So asking whoever is making the decision to consult with, in your example, both the parents. But if there still is a disagreement that can't be resolved in that way, you can make an application to the Court of Protection and ask for the court to make a best interest decision. And the Court of Protection has the power to make really wide-ranging decisions. So it can make decisions about someone's welfare, so, you know, where they should live, the care package that they receive, who they should be in contact with. That's quite a common concern that people have. And so the court will be getting evidence from the relevant parties. So in your example, both parents and any statutory authorities that are involved, and then has the power to declare that because the person lacks capacity to make the decision themselves, that something should be done in their best interests, and that would be in the form of a binding court order. So that's the redress you have if you can't resolve it informally through the best interest process.
Fantastic. That's really so. Another question coming into the Q&A is, when somebody dies, and there is a need to organise a funeral, and if the next of kin is refusing to get involved or doesn't want to involve patient, what are the rights then at that point?
Right, to be honest, I only deal with people when they're alive. As soon as they die, it goes off to a probate solicitor. But really, it would be dealing with the estate, and it would have to look at the statute as to whether there's a will as to who can basically look after their finances to be able to pay for a funeral and pay for all those expenses. So there's normally a department in the hospital that would help with that. I've certainly liaised with hospital departments before when there's been a bereavement and no immediate knowledge as to who to contact.
Yeah, brilliant. And then another question in there, but I think we've covered that now, is if the nearest relative next of kin, power of attorney, is not communicating with the rest of the family, the rest of the family still have a right to ask for a best interests meeting to make that decision, so that they can get more involved in it.
Yeah.
That's really helpful. Now then, some of the queries that have come into our helpline in the past have been around members. So say my parent has put two family members down as next of kin, I guess that's what it's called, next of kin, and I decide to remove my other family member. Can I remove a family member if somebody's listed them as next of kin?
I've had this query as well, and to my knowledge, no, basically, because if someone has capacity and they've named 2 people or 3 people on their forms, then no one else should be able to remove them. But we do come across this story. Yeah. I don't know how it happens, because it shouldn't happen, but you do tend to hear stories of particularly warring siblings when they manage to get the other one off the paperwork. But it shouldn't happen.
Yeah.
And in either way, sorry.
No, I was just going to agree, because if the person has said, I want both these people to be contacted, that is their wishes, and if they've declared that at a time that they were able to, that should be followed.
So the person that happens to then would go through the best interest decision in contacting the hospital to say, actually, my dad said I was to be on the...
Exactly. Mm-hmm. And then if it still can't be resolved at that stage, hopefully it would be, you can apply to the Court of Protection to make a best interest decision about, having contact and having information about the person.
And the Court of Protection best interest decision wouldn't be about the other person being removed per se, it would be about you being added.
Exactly. The Court of Protection, when it's looking at contact, is how it's defined. It can make restrictions on a person's contact, but in this stage, in this example, it would be about you being added, unless there were any concerns about the other person that you made clear to the Court of Protection as a reason why they should be removed.
So for me in all of this,
I was just going to say, one thing that we haven't spoken about that I think is a great idea for anyone to think about is doing something called an advance decision, which is not a power of attorney and it's not a deputyship, but it's really just a statement setting out what, usually in relation to medical treatment, but what you do and what you do not want to happen, because it really takes it really helps those who are looking after you work out what you do want, and can often mean that there aren't these disagreements between people trying to work out what you do want at a time that you've lost the capacity to make those decisions. And anyone can do it. You just need to write an advanced decision saying, this is what I would like to happen. Put it in writing, attach it to your medical file, and then so long as there are no issues with the fact that you have capacity and that you did it when you were an adult, the medical professional should follow that. And it often takes away any questions about what you would have wanted, because that often comes to the heart of this, trying to work out what is best for this person. And if you've made your own advanced decision, it's clearly set out in writing.
So you said there about the advanced decision that you can attach it to your medical file. Do you mean you can attach it to your NHS medical file, or?
Yeah, if you send it to your GP, they should put it on your file, and it should be available for any medical professionals looking after you.
Wonderful. We must look as an organisation into the NHS app and see if that's recording your advanced directive as well.
Yeah, that's a good idea.
Yeah,
that'd be good, because actually you can then make sure, because it's a good idea to keep it under regular review, just to make it more likely to be it would be valid anyway, but make it more likely to be relied upon. And actually, if you can access it yourself, that would be much easier.
Yeah, I must check that. I don't know the answer to that. It's just come up when you mentioned that, so I don't know if any of my team on the call know whether this is reported on the NHS app or some of our NHS colleagues who are on the call. But if not, we will raise it. But that's a good place for it to be. And you talked a little bit about advocates, and I know you talked about it more under the Mental Health Act, that you can apply for an advocate to be a professional advocate to be appointed. Is that the case across the board? If there was, family members just weren't able to agree, is that something you can do under a best interests decision meeting, or?
There are certain circumstances where someone should have an advocate appointed. For example, if you're deprived of your liberty living in a care home or other care setting. And so there are certain circumstances where you are entitled to have an advocate, but not all circumstances. But equally, as you suggest, it's a really good way of making sure that a person's views are being put forward and advocated for independently of family members if they disagree. So quite often, as a suggestion, it's taken up because it's a really good way of making sure that best interest decisions are being made properly if the person has an advocate able to look at things independently and be an advocate. There are other organisations, if family members as well are struggling to make their views known, that can also advocate on behalf of family members. And so they can also be contacted in certain circumstances to see if they can help.
Brilliant. And then I'm just going to go back to the power of, I'm reviewing some questions, go back to the power of attorney. So I write a power of attorney and I'm quite happy, and then I fall out with the person that's on my power of attorney. Life's normal. If I want to disagree with who's on the power of attorney while I still have capacity myself, what do I have to do?
So you can just make a new power of attorney. You can revoke the previous one. Yeah, while you've got capacity, you can just do a new one. Absolutely, yeah.
And it is really important to keep them up to date, because things do change, and so keeping them under regular review is really important.
Brilliant. So I think what I'm hearing is that the immediate action for somebody who has a concern that they're not getting the information about somebody in hospital, that somebody else is withholding, they're not handing on the information, it's not being shared with the wider family, and especially when there's visiting restrictions and you weren't able to get in and see the person, your best thing then is to apply for the best interest meeting.
Yeah. As a starting point, it should be language that is very well known to medical professionals and other people caring for a person, and so it's asking for a best interest meeting or a decision or a best interest decision to be made. It doesn't have to be done in a formal way. It's just and it can be done in a large number of different ways. But just saying I would like a best interest meeting, a best interest decision, is the starting point.
And so if the level of information that's been withheld from you is you don't even know who's caring for your loved one, would PALS be a good option to start with?
Absolutely. And I think any concerns that you have about the treatment that someone's receiving or information that you're getting, PALS is a really good starting point, and they should be able to help you work out who is the best person to talk to at the hospital.
Fantastic. And we're going to look at some of our information and see what else we can add, and maybe some templates. I don't know, but we'll have to think about that to make sure that we can be giving, because this is all about giving patients and their loved ones that power in communicating and having the control that they rightly want and deserve about what matters next to that person.
Yeah, absolutely. And it's making sure that patients, if they can't communicate what they want for themselves for whatever reason, that the right people are being spoken to, and that all the information that's available is being communicated. And that's really important to make sure you're making the right decisions for a person, because we all have different things that we want and don't want.
We are down to 2 minutes left in this webinar. Is there anything else that you feel that we haven't? I think we've talked about the first steps, concerns about next of kin, go for the best interest decision. Is there anything else that that you feel we should be adding right now?
I think we've covered a lot.
Got time to talk about DNAR?
Yeah, the last thing that I get a lot of inquiries about, and I'm not so it might be of interest to those attending today, is concerns about a do not resuscitate order being placed on someone's medical records. We often get concerns that someone's looked at their mum or dad's medical records and have seen this, and it's a real surprise to them. And what the law says about that is that a patient and those involved in their care should be consulted about any do not resuscitate order that is put on someone's file. So there is an obligation to involve the patient and or those making decisions for them in that process. What they can't do, though, is object to the order itself being placed on the file, so long as they have been consulted with. And that's because the law says that a court will never be able to compel a doctor to make a medical decision that they think is not medically appropriate. And so the obligation there is the consultation, so making sure that you're being consulted about do not resuscitate orders. But so long as that consultation process is followed, there isn't a way of saying to a court or any, in law, that shouldn't be on my file, because that's a medical decision that the courts can't get involved with.
But if the consultation hasn't happened, what would be the steps that you would advise to the family members?
The first step I would advise is a complaint to PALS and asking for the consultation to be, well, even before that, a conversation with the treating team saying, I've noticed this on the file, I want to understand some more around that and be involved in the consultation. If that doesn't resolve it, a complaint to PALS is where the second step I'd advise.
Okay, that's quite stressful if it's something you don't agree with, and yet you have to wait to go through the PALS complaints process.
Yeah. Yes, there has been various legal challenges about whether there are other ways to challenge it through the law, but at the moment it's the consultation process that is the thing that must take place. And so that has, I say recently, that was clarified in a court case, and so it is now clear, and all doctors should know that there should be consultation before placing that on anyone's file.
Fantastic. Thank you, Anna and Amy. I think that's been really, really helpful. You've clarified things in my mind and got me thinking about other bits that we can do as an organisation to support patients. And thank you to all our attendees and participants, and for all the great questions that helped me. And again, really sorry about our blip at the beginning whilst we were searching through the internet looking for Anna and Amy and hoping that we found them, but we did, and it's been great to find you. And this will be available on our website over the next few days. And obviously our helpline are always there to support and give guidance to any patient or a member of their staff. Lovely. And on that, we will close today.
Thank you. Thanks so much.